Alright, more fun with the asshole here. Okay, so now he's still on the tax amnesty program and the 5%. He's basically conceded that, yeah, you're required to pay the 5% if you want to protest the tax, and he just said, it sucks to be you. That's his response to that. And then I, again, state in the video that, it's the only one I could find was Delaware. And so then he does his little googly typey thing, his little Wikipedia thing, his little bullshit thing, does the same crap he did before, do a superficial look, and there say, gotcha, but he's wrong again.
The distinctive aspect of the Pennsylvania program is a requirement that amnesty participants file all required state returns and pay all required state taxes due within 2 years after the last day of the amnesty period. Proposals for a tax amnesty had circulated in the Pennsylvania state legislature for a number of years. One general amnesty bill was struck down by gubernatorial veto. The concept of a general tax amnesty received renewed support in 1994 when gubernatorial candidate Tom Ridge pledged to seek an amnesty program combined with stepped-up enforcement against tax violators.
So he's reading all this extra crap.
In the final legislation, the general amnesty was combined with the enactment of a 15% non-participation penalty for tax liabilities collected after the amnesty. In addition, the legislation made appropriations with a key...
So 15, that was the only part they need to read, that it included a 15% penalty. And their newer, the more modern amnesty, the 2009 amnesty, it's down to 5%. It's like the New Jersey one. But let's just keep going.
Integrated tax system, a new computer technology system designed to enhance the state's ability to identify delinquent taxpayers.
Pointless.
So, well, there you go.
Yeah?
This is just really, really, really sad.
Okay. Well, you want to see the sad part? Is that you play this game like you did something, you accomplished something, you made a solid, valid argument, and you made nothing. All you did was, again, add noise, distort, distract, and in essence, slander. Because here's the truth, okay? Right in the document. I mean, it's not that hard to find. Delinquent eligible tax. This is the bill. An eligible tax was unpaid, unreported, or not reported as of June 19, and which has not been appealed, or which has not been appealed, and the appeal has been withdrawn, or dismissed, or denied. So if the tax is being appealed, okay, there's no penalty. That's the difference between the New Jersey law and the Pennsylvania law. You still retain your right to go to court and appeal the tax in frickin' Pennsylvania, and you don't have that right in New Jersey. And that's why I equated it to threat to bargaining, is because it drives you out of court. It basically says to you, we're going to make you pay if you protest this tax. That's the unconstitutional part of it. You can't take away a person's right to redress of grievances. It's in the Constitution, the right to redress of grievances. You can't extort somebody out of court, you stupid fuck. So there you go, smart ass.
So, yeah, Gary. 15% tax.
Exemption for people appealing the tax.
Penalty on the taxes for Pennsylvania.
The say here, because this would be very easy. You just wasted a whole bunch of time reading something where you didn't...
I make the same. The reading again. He did his little reading, didn't read the important part. When he did the cigarette taxes in the state of New Jersey, right? Didn't read the footnotes, didn't read the facts, didn't even care to find the facts. Okay? Just played his stupid fucking game and ignored 75% of the tax. And here ignored the most important aspect of the law, which was an exemption for people appealing the tax. Fuck you. Alright, he's just spending time gloating, so we'll play some of his gloating just to mock it, and just to point out that it sucks to be you, somebody who can't seem to get a single fact right.
You cheated on your taxes.
Well, whatever. I mean, guys, you can't cheat when the tax, in my opinion, is unconstitutional. So I'm not...
Well, no one gives a shit about your opinion, Gary, so you did cheat on the taxes, and you went out of your way to avoid the taxes. So, yeah, go fuck yourself, you little shit.
Yeah, right. Yeah, I did what everybody else did. I went to the internet when they want to get a bargain. So whatever. Yeah, again, you've made it clear. Okay, you think I should have to pay, all right, 1,000% more for cigarettes than you should pay for your luxury vices and whatnot. Okay, I got the double standard. It's clear. You're a fucking bigot. Okay, you've second-class citizen to me and says it's okay. So fuck you and your fucking plea for a fucking right, you stupid ugly cunt. Yeah, fuck you. That'll be the battle cry. Fuck you. I'll write it on a flag for you, okay? Fuck you, turd. Yeah. Anyway, let's just do this again, okay? I mean, he did a bunch of gloating, so I'll do some gloating. And which has not been appealed. There we go. And which has not been appealed. There. All right, back to the argument. So he's still claiming that it's not an 800% tax. I'll just say let's change the word to levy or total fee or net change in market price imposed by government. I mean, clearly government has interfered, and cigarettes that should cost 75 cents a pack or less now cost $7.50 a pack or more. That's what the government has done. It's interference. So let's just say an 800% price increase due to government interference in the fair market price. So really, is that we have to strangle language because you're going to play some game that the taxes don't exist, that the total interference of government doesn't come out to 800% change in price? Anyway, then he says, so he made some crack about me saying it's a fake judge. You know, I'm claiming it's a fake judge. Well, yeah, I'm just saying the justice was obviously pitiful, and the judge obviously wasn't any good at being a judge because he didn't even know his jurisdiction. And so now I again just point the question, just explain, give me one reason, one rational reason besides just bigotry and majority exploitation for the differential in taxes on alcohol and cigarettes. And here's going to be his response.
Then fine. But you're not going to be able to construct that reason because it doesn't fucking exist.
Well, lots of people have given you reasons, Gary, including...
No. What reason? Where? Show me the reason. Show me any kind of rational reason. You haven't done that. There's no explanation of any reason. What's the reason?
The judge, and I think I've made my case in multiple videos now. So again, you're just one.
No, you haven't made any case. You haven't made a single argument. There's clearly similarly situated vice is not being taxed similarly. It's clearly unconstitutional, and you're just going to pretend it isn't because you're a bigot and a tyrant, and you have no principles or integrity, and you're intellectually dishonest to the max. Sucks to be you. Sucks to be near you. Sucks to be friend to you. Yeah. It just sucks.
I mean, because you're a little bitch.
Well, whatever. Yeah, that's... Yeah, so there. Direct question, direct challenge, and your response to the challenge is nothing. Absolutely nothing. Nothing. All right, back on the amnesty bullshit. Okay, so he's claiming that somewhere I said the amnesty program or something was directed towards cigarette taxers, or somehow I said it was unconstitutional because of its effect on cigarette smokers. I never said any such thing. I was arguing that the amnesty program is unconstitutional because it denies people access to their constitutional right to redress of grievances. You can't impose a penalty for people who are protesting a tax legally, who are in the legal system, as Pennsylvania's law provided, and which has not been appealed. Simple, right? Yes, that's why New Jersey, this law was legal, New Jersey's law was unconstitutional. That law is constitutional. New Jersey's law was unconstitutional because New Jersey's law did not provide this protection for people appealing the tax. Idiot. Yeah, so this is what he's going to say again.
Say you're guilty and pay the tax, they will penalize you for going to court. It's that fucking obvious.
No, they'll penalize you for not paying the tax. The fact that you go to court's irrelevant.
Yeah, so that's why it's written into the law. is because it's irrelevant.
They'll penalize you for not taking advantage of the amnesty, regardless of whether you try and go to court or not.
Yeah, regardless. That's why it's in the law, because it's regardless. No, I'm afraid not.
So, no, Gary, it's not written in there that, oh, gee, if you try to go to court, you have to pay 5%. It's you have to pay 5%.
Yeah, there's the exemption, quite obviously. If you go to court, you don't have to pay the 5%, the 15% in Pennsylvania. There it is, right there. If you go to court, you don't pay. It's right there in the law, fuckhead.
And if you don't participate in the program.
That's why
So you lose again.
no other states have ever done it. It's because it's
Except for all the states who have.
Yeah, except for the ones you lied about, the ones you distorted and propagandized about, right? You got the wrong information, the wrong facts. You stated your pompous and arrogant opinion, and you were wrong once again. Because you're just a lying sack of shit propaganda motherfucking cunt.
that obviously wrong.
According to Gary.
Well, no, according to the written law that you overlooked again. Okay, so now we'll go back to another fact he got wrong. He started ragging on why New Jersey property taxes are what they are, and it was because there's too many municipalities, which is true, but the fact is it's really hard to go back once you go there. You know, once you make little towns really hate combining into big towns because, yeah, the other town's full of those people, or thems, or some other kind of crap, and they really don't want to combine, okay, because there's no, the advantages, even though they exist, they really don't want to call those other people them or us, and so they just don't do it. But he implied that I was one of the people standing in the way of the shared services and doing all. No, I've actually fought that. So if you actually went to the website inmendham.com, right, you'd see that, yeah, it's basically a site very hostile to the fact that these little government tyrants play these little games. And I was actually a huge supporter of the merging of the police forces and a huge supporter of shared services. And I was the one using the Open Public Records Act to try to force these guys to be honest for a change. So fuck you once again. I'm not just bitching. I goddamn did, you motherfucking cunt. You're the guy who just sits on his fat, fucking smelly, pimple-covered jackass and jackasses. Fucker. Yeah. Oh, all right. So now we're going to get on to some of the start of the motion for the judge to recuse himself and conversation about the intent of the judge.
It's completely bizarre procedure.
So again, he called to make sure that you were aware of the amnesty program so you could, save money in the end.
Yeah. All right. So that's your interpretation of why the judge called. Okay. I have the tape of the judge. All right. And so, yeah, this is just bullshit. Okay. He started off with some sort of we're not going to discuss the merits of the case, and yet he's going to critique the merits of the case. Why aren't I saying I didn't buy the cigarettes? That was his argument to me. And we're not supposed to discuss this case, and this is off the record. Now, I don't think you quite understand how the judicial system is supposed to work, but the fucking judge is the umpire, okay? Umpires aren't supposed to do this crap. They're not supposed to be making off-the-record phone calls to anybody, all right? And every paper being filed, everything done in the case is supposed to be on the fucking record. That's the whole point of having the trial, is so that if something goes wrong or a judge makes a mistake, you can go to an appeal court and show them the record. That's why you have a record. Fucker. Jeez, you're dumb.
And he wasn't required to, but he still did it out of basically the kindness of his heart.
Well, whatever. Like I said, if you think that's what judges should do, they should, out of the kindness of their heart, call up the plaintiff in cases and basically ask them completely irrelevant, insanely irrelevant to their case questions that they're not allowed to answer. Right? He told me I'm not allowed to answer why I don't claim I didn't buy the cigarettes. Because to answer why I'm not claiming I didn't buy the cigarettes would require me to discuss the merits of the case. Yeah.
And you complain about that.
Go ask somebody go ask plaintiffs how many times they had judges call them before the trial starts. Go ask them how often that one happens.
Well, you don't know. Why don't you look that one up, Mr. Brainiac? Why don't you go look up what judicial procedure is supposed to be and see if you can find judicial procedure somewhere where judges are supposed to call up plaintiffs off the record, okay, and inform them that there's a coupon for banana splits or whatever at ShopRite. That's their job, is to help them out in their life. No, that's not their fucking job, turdhead, and we know what the judge was up to. He was driving me out of his court.
Nothing, Bubba. Yeah. No, so, yeah, we're going to take the judge's word for it, are we?
I'll take the judge's word over yours, certainly, because, you know, the judge is a qualified expert on the law and...
A qualified expert on the law who doesn't know what the United States Constitution is or the fact that he has jurisdiction. So there again, that's your definition of qualified expert on the law. Yep, and you know, the law on recusal, you know, basically does say if a party has reason to believe, or parties, they use the word parties, so that's the catchy part of it. But the bottom line is all you're supposed to really have is some reasonable belief that the judge has a bias. You don't think it's a reasonable belief if a judge calls you, completely perverts your complaint with a bizarre question, like why are you saying, you know, you're not an axe, you didn't buy the axe or something in an axe murder case or some kind of stupid thing like that. You know, I mean, it's just bullshit. You know it. Well, you know it. You're just playing the game because you're a petty fuck. Turd. Asshole. All right, a couple of issues, I believe. Okay, again, he brought the 15% penalty in Pennsylvania, and yeah, of course, as we've shown, that didn't apply to people protesting the tax. Okay, telling the truth. Would you? Well, anyway, yeah. So he's claiming that he's not lying, and I would argue that, of course, you're lying because there's no way you would want a judge to make off-the-record telephone calls in legal cases. There's no way you would want that, especially in your cases. You wouldn't want the judge having private conversations with the other parties. You'd say that's insane. That's crazy. Put it on the record, Your Honor. You know, you'd find that appalling, and you know it. And you'd certainly want judges that knew their jurisdiction. You'd certainly want to be, you wouldn't want to have to go before a judge who doesn't even know what jurisdiction is, doesn't even know what the United States Constitution is, and that he swore an oath to uphold it. Yeah, I'm sure you wouldn't want to go before that kind of judge. So you're a liar in the sense you're defending preposterous judicial process that you wouldn't want to be exposed to. You wouldn't want to argue a case before a judge that incompetent. You know it. So then he argues that, what am I doing, but complaining about a tax that I say the fee, the amount of money I had to pay was so little, blah, blah, blah. No, look, I paid for these cigarettes, all right, in Kentucky. I paid $30 for just getting them in Kentucky. So I already paid federal taxes. I paid all these other fees. So this is just the extra tax being applied, a second tax by New Jersey. And of course it's onerous, but I'm just saying compared to the cost of filing legal documents and going through all this other process, it's not that much money compared to that. But for the simple liberty of smoking cigarettes, which I've done for 40 years as a free American, and all of a sudden I can't do it as a free American anymore, yeah, it's a preposterous goddamn tax. So fuck you and this game playing. So now he's on to the sequence of events. Okay, so let me just say, for the record, I haven't been to my cigarette tax website in 5 years, 6 years maybe. A long, long time. I haven't gone to it for any of these videos. I'm just going based on memory. All right, so, and so he thinks he's going to do an I gotcha here. We know what the judge said, and that's all that's important. Whether he said it in one conversation or he said it in two conversations seems to me pretty irrelevant. Okay, what's on the record is transcriptions of the conversation. Clearly, the judge initiated the conversation with me with two subjects. The first subject was, we're not going to discuss the merits of the case, but please explain why you're not saying you didn't buy cigarettes when your complaint says you did buy cigarettes, which is nonsensical. And two, that he informed me of a tax amnesty program as if I'm somehow obliged. He says, and there's a 5% penalty. He said that in big letters, big words, he emphasized the 5% penalty. The 5% penalty that's exempted in the Pennsylvania law for very rational constitutional reasons. So a judge is telling me I'm subject to a 5% penalty if I continue to process my court case. You think that's valid procedure? I say that's fucking bullshit.
The other thing is the amnesty law. This is the judge. So, judge. The other thing is that the tax amnesty law provides that if your case qualifies for amnesty, Garrett doesn't know the proper difference between your and you are, qualifies for...
Right, it's a quick transcription of an oral conversation, and this is the kind of shit this asshole thinks is important.
Amnesty, and you don't take advantage of it, there's an additional 5% penalty. Then Gary says, quote, well, I think that's probably unconstitutional, too. Again, he doesn't know the right version of the word too.
Well, it doesn't matter. What's obvious is that this is already into the conversation because this is the second time I've informed this judge that he's violating my constitutional rights. So in one conversation, he's violated my constitutional rights twice. Twice I've had to appeal to my constitutional rights in an off-the-record conversation with this fucking cunt. And I think right there you have pretty solid evidence that we have a problem, fucking Houston. If a goddamn plaintiff has to argue their constitutional rights twice in an off-the-record conversation with pre-trials with a judge, then I think there's a fucking problem, shit for brains. Two times. 2 times he had to do that. 2 times.
But that's fine. Then, oh, look at this. Attorney Goldschmidt. Judge, I had sent a letter out a few weeks ago to Mr. Moser, just going through some of those things for him. Really? So she wasn't in the call? Well, according to your own documents, she was, Gary.
Well, and how does that change anything? Again, it doesn't make any difference. Okay, it almost just validates my point even more. An off-the-record conversation. So you send out notice that there's going to be a teleconference, and yet the teleconference isn't on the record. Now, does that make any real sense? No, it doesn't. I mean, I've seen what happens in these off-the-record conversations, and they should be just totally illegally. There should be no right to have off-the-record conversations because what these judges do is disgusting.
So, apparently I know more about your case than you do.
Well, apparently it's a 10-year-old case, as I pointed out. You're the one with a boner for it, okay, asshole? You're the one making claims about it. So, yeah, I'm defending it, but I'm not going to waste my goddamn time going back through something that I find to be a bitter, disgusting, sad, tragic segment of my life. Being exploited and abused by motherfucking cunt bastards like you. People who defend liars on our courts. Fuck you. Fuck you, Matt. Okay, that's all he's got to say. So we'll be back. So, in this part, he's ragging on the fact that I shouldn't have this expectation of any kind of expedient justice or fair justice or any of that kind of stuff, right? And so, like I said, this case was 2 years before I even got to have this off-the-record conversation where I'm informed that there's a 5% penalty if I pursue my claims. That's in essence what took place. After 2 years, I'm informed that there's a 5% penalty if I continue to prosecute my case. I'm called by the judge and informed that there's a 5% penalty if I continue to pursue my case. Yeah, right, that's justice. Let's see, Gary just... whatever, I don't know. All right, so then I pointed out that I had another case for 7 years. And so he just keeps... You know, this is the lying part, right? Because there's no way you would want that kind of justice. You certainly could understand that there's a way that judges can make stuff go away is just to delay them. You delay them and witnesses die and stuff happens, and so you can make a case go away just by delaying it long enough. Because everybody will just say, fuck it. You know, there's no chance anymore. I can't get a fair trial. I'm supposed to go back 7 years, you know, to argue. I have to argue what happened 7 years ago. I mean, come on. That's why they have this right to an expedient trial thing. is because, yeah, the more time between your claims and the events, the harder it is for you to prove your case. But yeah, you can't understand that? No, I think you understand that quite well. You just, again, don't care, and you just care to propagandize. So anyway, here's the part where he's reading the judge's decision on the motion for recusal.
In my recollection of the telephone conversation, I find nothing to warrant my recusing myself from hearing this matter.
Right, he doesn't address any of the points I just made, right? So I make points, he doesn't address any of the points, he just says I'm not going to recuse myself. Well, that's fine, he has the right to do that. Okay, but the law does say if I have a reasonable
Well, Gary, he read out the law, and he also, showed why you were incorrect and why he doesn't have to recuse himself.
Well, I'm sorry. You're saying he showed? He didn't show anything. He just said, I'm not going to recuse myself. He doesn't explain how this is acceptable judicial process, how other cases... Well, judges all the time forget their jurisdiction. Judges all the time call people up and inform them there's a 5% penalty if they pursue their case after 2 years. This happens all the time. It's not a big deal. So no, he didn't do any of that. He didn't explain how this was common procedure or fair procedure or reasonable procedure, how you tell a party, we can't discuss the case, but here, I'm going to ask you a direct question about the case. Okay, you can't discuss the merits of the case, but I'm going to ask you direct questions about your complaint. He didn't explain how that's reasonable. He didn't explain how it's reasonable for him to characterize my complaint as, you're not saying you didn't buy the cigarettes. That characterization is preposterously stupid. So no, he didn't explain any of that. So you're a liar again. Okay, because he clearly didn't explain any of it. He didn't explain how what he did is consistent with me believing he is reasonably competent.
So he did answer your point.
reasonable belief that he has a prejudice against my case, that he should recuse himself. That's what the...
And you didn't have a reasonable belief.
Law said.
So that's it. So, what the hell? So in his opinion, I don't have a reasonable belief that a judge is biased against my case if he asks me the question, why aren't you arguing something you explicitly say didn't happen in your complaint? Why aren't you saying exactly the opposite? And informs me of a 5% penalty if I don't stop pursuing my case. And I'm supposed to not have a reasonable perception of bias against my case. This is all in an off-the-record conversation, where the judge informs me he doesn't have jurisdiction over constitutional claims, where he mocked, in fact, those constitutional claims, where twice in the off-the-record conversation I had to appeal to state that I think that's unconstitutional, Your Honor. I think it's unconstitutional, Your Honor, to threaten me with 5% penalty. I think it's unconstitutional for you to characterize my complaint and then tell me I can't defend myself against your characterization. Yeah, no, I'm sorry. It's a reasonable belief. And if you think it's an unreasonable belief, you're an unreasonable liar. You're a liar if you don't think that was I reasonably believe the judge had a bias against my case. If you don't think I had a reasonable belief that the judge was biased against my case, you're not honest.
I think my belief that he has compromised his impartiality was quite reasonable.
Well, no one gives a shit what you believe, Gary.
Well, again, no one gives a shit what you believe. The law says what I believe is important. If I have a reasonable belief of bias, the judge is supposed to recuse himself. That's what the law says, shithead, so it's not no one cares. The law fucking cares. And if the law was fucking honestly applied, okay, the judge should have recused himself. It's quite fucking obvious. But again, it's just because you're a petty liar, okay, that you'll state otherwise. But you wouldn't want to be treated that way. You're just such a piece of fucking turd work.
In my case. I mean, it's a huge...
And he misspoke, and he addressed all of your arguments in the complaint.
All right, so right there, do you think that's an honest statement just made? He addressed all my arguments in the complaint in his decision. He didn't address any of the arguments after 9. Okay, none of them. Where did he address the argument of discrimination? Where did he answer the accusation of discrimination in his decision? Where? It's not there. He didn't answer a single argument in the complaint. He just said, it's okay to tax cigarettes. That's not in my complaint. Okay, so, again, you're saying what you just said is honest. That you think the judge did answer the complaint. I'd say that's just a grotesque lie. I think you're an idiot, and I think you're stupid, and I think you suck. But I don't really think you're dumb enough not to realize that he did not, in fact, answer a single contention in my complaint. None. Except the privacy issue on the Jenkins Act, which was the part of the case he wouldn't let me argue. Isn't that interesting? The thing he spent the most time on was the thing he wouldn't let me argue. And that's the part of the case where he compared cigarette smokers to pedophiles. Well, not even pedophiles, to child molesters, convicted child molesters. He compared cigarette smokers to convicted child molesters. Oh, no, he's not a biased judge. God, you suck. You just suck.
Ad nauseum.
So, ad nauseum. In his final decision, there's an ad nauseum explanation for how, explaining how this is why alcohol taxes are taxed at this much, and this is why cigarette taxes are this much, and this is why these are not similarly situated classes, and this is why they can be treated dissimilarly. He did that ad nauseum. No, you're a liar. He didn't do that at ad nauseum, did he? No, you're a liar. Okay, he didn't come close to doing it at all. Liar.
Error on his part. But yeah, let's not pay any attention to that.
To measure read into the... Well, Gary, since you haven't watched my video yet, up until that part, you haven't watched the rest of my video, you would have seen that I had brought up the constitutional claims.
You brought up? Who cares what you brought? We're talking about the constitutional claims that the judge didn't answer in his final decision. So I don't know what you brought up, but it doesn't matter what you brought up. The fact is, it's not in the judge's decision.
Obviously, the transcription of his recording of our conversation, a recording made without my knowledge or Mrs. Goldschmidt's knowledge, and the transcript appears to be accurate and is consistent with my notes. However, Mr. Mosier did not place into the record his argument.
Yeah, whatever. This is just the part where I said, yeah, I'm not going to transcribe telephone conversations for you, you cunt, for off-the-record conversations. You transcribe it. Here's the tape. You do it, fucking Your Honor. You cunt. Anyway, continuing later. Oh, I did. All right. Well, he's back to the misspoke again. Amazing. You know, the judge misspoke about his own jurisdiction. He graduates from Harvard Law School, and he misspeaks about his fundamental jurisdiction over claims of a constitutional right. In an off-the-record conversation, again, he misspoke in a conversation he didn't think was being recorded. And that's the bottom line here. And somebody shouldn't be suspecting bias. Another context you should understand, you and anyone who's bothered to listen to all this crap, is there is another constitutional, now established because of Supreme Court decision, judicial obligation. So in cases where a pro se plaintiff, that is a plaintiff not represented by a lawyer, makes a claim of something that even looks like a claim to a constitutional right, a claim to a constitutional protection. Anything that has even the vague appearance. I write it in crayon. Red rum, me righto. Right? I write a crayon complaint. The judge has an obligation under the law, an obligation under Supreme Court precedent to try his best to find a constitutional right and defend it for that plaintiff. That's the judge's obligation, is to give a pro se plaintiff. This is the only advantage pro ses have. In every other category they are slaughtered, but in this one category they are provided the benefit of interpretation, and the requirement is to give them every benefit of better construction. So if they have anything close to a claim to a constitutional protection, the judge is to see it, not see it. That's his obligation. is to find it, not ignore it. To side on positive error rather than negative error. That's his obligation. So you're saying under that circumstance, a judge should say in an off-the-record conversation to a pro se plaintiff that he doesn't have jurisdiction over the rights the plaintiff is claiming. And you say that, again, is constitutionally consistent or consistent with Supreme Court precedent? Well, it is not. It's a violation of that precedent. It's a fucking abomination to leave this case held the way it is. And the reason why it is like this is because I don't have a Dershowitz, I don't have some lawyer, okay, with a name to show up and shove this in the public eye and to shove this in a court where they're going to be obligated to answer these charges of goddamn miscarriage of justice, of goddamn judicial abuse. Appeals courts who don't write decisions. It's nonsense. Oh, I forgot to play his part. Yeah.
I'm defending the fact that he actually enforced the Constitution, Gary. That's what I'm defending.
Yeah, whatever. Like I said, how could he possibly be doing that when he's violating Supreme Court precedent all over the place, where he has preposterous reversible error, where he has fouled the case on the most critical element of a case, which is jurisdiction. It is the most important foundation upon which cases are begun, is the obligation to establish jurisdiction. And if the court gets that wrong, it's a mistrial. You won't have any criminal trial, no other trial will be sustained if a judge fucks up jurisdiction. Idiot. Asshole. Petty
I know what you're
fuck.
defending, but again, I'm defending the Constitution being appropriately applied. And the reason why he didn't answer a lot of your raft of other issues, being like, let's.
Yeah, so you just said there's a raft of other issues. We see the derogatory character of that claim, and you're going to give a reason. You're going to tell me there's some reason he has an excuse not to answer claims in a complaint. He doesn't have a right to do that.
Look, is he supposed to answer fact? Cigarette taxes consume 20% of my disability income. Contention, as one of the rich ruling class, you like regressive, quote, stupid poor people, unquote, taxes?
No, he's supposed to answer the charge. That's what this is, and it's under the context that this is a description of why it's unconstitutional. And as I just stated, he violated my rights by saying I couldn't argue the Constitution, so all I could do is put the statements in there. How else could I construct the argument? I'm not allowed to argue amendment rights. He's already prohibited argument on the Constitution, so I had to phrase the argument in some way where I'm indicating there is some sort of general right not to be abused. You stupid fuck. There we go. Okay, so this is just so tedious. All right. So he's gonna. All right. So we're on the summary judgment motion now. So it should be understood what summary judgment is. Summary judgment is when one of the parties decides to try to just say I'm innocent, or I have absolute proof of the case, and just to end the case, just to get over with, because there's some sort of, usually it's the defendant is saying, I'm innocent, and here's how I'll prove my innocence, so we don't need to have a trial, because I can prove myself innocent. And that's usually the nature of summary judgment motions. But the obligation is basically beyond a reasonable doubt proof. You're basically just going to prove the case in an argument, and so there's no need to have a real trial. That's what summary judgment basically is. So the other party, the attorneys general, argued the case as if look, it's over. We won. Okay, here's the argument. Now, they did that based on the guidance of the judge saying United States constitutional issues are not can't be argued in this case. So that summary judgment motion didn't need to address any constitutional issues, federal constitutional issues. Okay, it was made exempt from that because I'm not allowed to argue those. And my response to the summary judgment motion can only be a response to that motion. So again, I'm confined in what I can argue in defense, in refuting that motion. So obviously that motion isn't conceding my constitutional claims I can't bring my constitutional claims into the argument. So that's the closedness that's the implications of this judge's error on jurisdiction. So if you're to say he did argue it, he did write a decision explaining it, he didn't do any such thing. Fucking mimicking, just reciting a Supreme Court decision does not explain how the law is applicable. Go show me a Supreme Court decision where the Supreme Court just says, well, in Sutter versus Manakatu, they said this, and that's all we need to say. We don't need to explain how this case over here is applicable to that law. Of course you need to explain how it's applicable. How did the judge explain it's applicable? He just said we can tax cigarettes. He didn't explain. He did not use the word discrimination or the word excessive. He did not argue the case. He did not provide an explanation of the applicability of the law. And again, the critical point is that I was denied my right to argue my constitutional rights. I mean, how can you defend that? Well, you're not defending it. You're just being a fucking petty weasel. That is your nature. That is the nature of the weasel beast.
I get to say nothing more in the case. All right?
Well, you did bring up your constitutional claims, and...
Again, I'm not going to argue. I brought them up in the fucking motion to recuse. Okay, and what I had to argue in the argument was state law, and I was denied my right to quote Marshall, to quote the great Supreme Court justices on these issues of discrimination.
He addressed them in his argument, his closing statements there, and he explained why you're wrong and then made it...
Well, whatever. He explained why I'm wrong. No, he didn't do that. He says it's legal to tax cigarettes. That's all he said. He didn't explain... I defy you. There's no point in me saying I defy you. You're a dishonest, lying sack of shit. It's quite obvious he made no reference to the concept of discrimination in his decision. So this is just a lie again. More lies. You're just such a fucking liar.
Ruling. So, yeah.
And that's what he's going to read now.
Upon him. Of taxes under the Cigarette Tax Act, New Jersey 64:40.
This might be interesting, so I'm going to play it.
And following particularly Section 8 of that statute. And under the New Jersey Sales and Use Tax Act, Legal Code, which taxes retail sales of tangible personal property.
Should be interesting, I think.
So he's reading this superfluous stuff.
Well, Gary, I'm trying to read it in context.
Which was conflated in your
Yeah, right.
Was repealed by the laws of 1990, Chapter 40, Section 1, and so after the effective date of that statute, which I believe was 1991, cigarette tax, cigarette sales were subject not only to tax under the cigarette tax, but also to sales and use tax.
Again, nowhere in my claim do I say it's unconstitutional or the state can't tax cigarettes. It's not my claim. My claim is that they can't disproportionately tax cigarettes.
So there, they changed the law in 1990, okay, again, for only cigarettes. The only items exempted, changed the law for, were cigarettes. So again, another category where cigarette smokers are now treated differently than any other class of citizens. So another example where laws were changed, perverted, distorted to be discriminatory against cigarette smokers and not against any other.
All right, well, I'll pick this up when he starts to say something, right? I don't know what he's doing here. He's doing his little typey type thing. See if he can go find some half information again. Do some more half arguing. You know, ignore the important part. And which has not been appealed. And which has not been appealed. Yeah. All right, now we're getting to some good stuff. But anyway, let's see. Let's get some of this. All right. So he made some rag about the fact that the illegal advertisement of the cigarettes. Well, you know, when the state chooses to regulate advertising, and it does regulate the advertising of cigarette products, then they have to take responsibility for the ads they say are legal. So if ads they say are legal are overtly deceptive, then they have to take responsibility for that deception. That's the only argument being made. So if the state's going to sit there and facilitate criminals' behavior, then they should be in jail for their criminal behavior, right? I mean, they're facilitating a lie, and then they're prosecuting people for being influenced by the liars. I mean, that's sort of a, you know, playing both ends, right? Burning the candle at both ends or whatever, taking advantage both ways. Then again, there was more little minor stuff about the sequence thing. I'm just saying when he made his response video, he sat there and was dealing with the motion for recusal, and then right in the middle of that, he switches to the judge's final decision, and then because of the sequence of his own video, he goes back to the motion to recuse. I mean, I just think that's a continuity mess-up. It just fucked the whole video in terms of the sequence of events. I mean, there's just no way somebody new to the case would find it easy to follow along when you're reading the final decision in the middle of an argument about a recusal motion. That doesn't make any sense to me. But whatever, fuck you. So here's the part. This is just the magic little part here.
There is a potential to persecute, end quote, and he regards the imposition of taxes here as a form of persecution. In addition to that allegation,
Yeah, and you'll find no response to that allegation in the judge's decision. None whatsoever. No explanation how it isn't a discriminatory tax, how the 800% number is
not 800%.
Well, again, you're going to keep arguing. I mean, just saying, okay, everybody, let's have a little integrity test, right? Just go do the simple math, okay? Cigarettes, when I was a kid, a carton of cigarettes was $3.33. They're now $75. Is there any reason except government interference that's responsible for that disparity? They should be probably about $7 or $8 for a carton of cigarettes. That should be the price of a carton of cigarettes, inflating in value the same as everything else in society. Production costs are actually gone way down. So this is just idiot. This is a moronic argument, okay? You want to keep pretending it's not a real $3,000 out of my life, carved out of my life by government interference? We'll go ahead and pretend that, but it's a lie.
Excessive, no response whatsoever to that claim at all.
Because it's a bullshit claim.
Well, there you go. So, okay, the judge acknowledges the claim. Okay, he states this is what I'm claiming in my complaint, and he doesn't respond to it. So you're saying it's a bullshit claim. He has to explain how it's a bullshit claim, how discrimination is not I couldn't use the 14th Amendment because he denied me the right to do that. But it certainly was a violation of my due process rights even under New Jersey state law.
And actually, he does address that tax code can be discriminatory, and it can target different people or different classes of things differently, and it doesn't have to be...
Oh, yeah, it does. This is going to be hilarious. No, similarly situated have to be similarly treated, okay? Not an iron rule, and does not have exactly precise or exactly equal. These are the terms used. There's nothing even close to any of that being argued here. I'm not arguing that tax isn't exactly equal. I'm arguing that it's preposterously discriminatory.
100% equal, which is why the progressive taxation system is...
Again, so now you're going to change the subject, okay? The point is this isn't an argument that it's not 100% the same. That's not being argued in my papers. It's not any part of my argument. My argument is the difference in treatment is preposterously huge. It's an ocean of space between these treatments.
Constitutional. Brief in response to the summary judgment motion, states as follows, quote, I would contend that even by today's established judicial perspective, consistent logic and justice requires any honest trier of fact to conclude that cigarettes have been taxed to unconstitutional excess. Currently... There,
so again, he reads my complaint. The accusation is that cigarettes have been taxed to unconstitutional excess. That's in my complaint.
Legal jargon requires a liberty interest to achieve fundamental status, being entitled to protection of obligating the state to demonstrate a compelling interest before it is allowed to abridge that liberty.
Right. This is the legal argument I made, part of the legal argument I made, stating basically this is the legal precedent. The law basically says you can't discriminatorily tax and excessively tax, blah, 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 blah.
I would simply argue that you cannot get more fundamental liberty interest than the one produced by a decades-long legal physical addiction.
All right, well, I'm not going to go through all this part. Wait till we get to the part where the judge says, oh, I made a mistake in his decision. He tells me he made a mistake. He doesn't reopen the case and let me re-argue the case. He just says in his decision, I made a mistake, sorry, my bad, you didn't get to make your argument, you didn't get to defend your constitutional rights in my court, too bad. I'll vaguely say, I think you have rights, but I'm not going to pay any attention. I'm going to throw them in the garbage. And that's justice. That's what you're defending. And so you're just showing yourself for what you are. I mean, there's no rational way to defend your behavior here, just as there's no way to defend the judge. You're just doing it because you're an asshole. You're a fucking evil asshole. A 5-year-old could figure out, oh, this isn't a fair game. That was stupid. That's not the way it should be played. That's very different than how it's played over here, over here, over here, over here. You can't do that. You can't break the game that way. The judge can't switch the goals in the middle of the night and then say play ball. That's bullshit. Kid could catch this bullshit. You can't put home plate in center field and then say play ball. You know, a little kid could figure that out. Alright, this part's been just kind of dragging along. But he says something about, do I know what a summary judgment motion is?
Do you not know what a summary judgment is, Gary?
Be sure.
See, he makes it kind of snarky remark. No, I think you don't understand what a summary judgment motion is, okay? A summary judgment motion shifts the burden to the person who files one. Now, why don't you read Goldsmith's argument, and then show me in Goldsmith's argument where she talks about discrimination, where she talks about alcohol taxes versus cigarette taxes, where she explains how the discrimination isn't invidious and all this other stuff. You know what she does say, which is really pretty funny? I mean, I actually have gone to the website now. I mean, this stuff is funny. I didn't realize how funny it is until I went back to it and I looked at it. I said, holy shit, this stuff is insane. Oh, damn, I'm not going to find it. Might not be in this, that might be in one of the others. But Goldsmith admitted why here we go. Both the Cigarette Tax Act and the Sales Tax Act provide vital sources of state revenue. Indeed, so important is a state collection of cigarette taxes as a source of state revenue, Congress enacted the Jenkins Act. They didn't enact the Jenkins Act for that purpose, but whatever, fine. There you go. I mean, she's basically conceding the argument. It's about the fucking money. Okay, there's a huge disproportional taxation for the money. So, but where in her argument? She had to prove no discrimination. She had to prove it. So show me in her argument, under summary judgment law, okay, the burden of proof shifts to the person who files a summary judgment motion. They have the full burden of proof. Where did she prove in her argument no discrimination? Where? Oh, that's right, she didn't. Yeah, so fuck you. You're such a fucking liar. Let's play a little more of this to see what happens.
Mr. Measure was aware of the tax amnesty program, then in effect, and pointed out to him that if he was eligible for amnesty,
yeah, okay, just reading the case off.
My apologies, the rest of the video is going to be very boring.
So
oh, he's not going to respond to the rest of the video, huh? Okay, well, we'll see. We'll be back, I think. Okay, so he's continuing to read the judge's preliminary statement, a description of events. So I just thought this part's kind of important.
No intent on my part to threaten Mr. Measure or to indicate to him that he had no rights to proceed in this matter.
There, that he had no right to proceed in this manner. So let's understand, though, that this is, he stated, I don't have a right to argue my constitutional rights. He called them, basically, also called that a raft of other issues. So here's Goldsmith. So here's what she said, okay? This is the Attorney General in the case. So this is the defendant in the case, and this is what she said. So the judge has told me I can't argue the Constitution, and this is what the Attorney General says. And they're saying this to a pro se plaintiff. So let's understand. Here's a Harvard graduate judge and a frickin' Attorney General for the state of New Jersey, Assistant Deputy Attorney General. That's her title. One thing I just want to make sure you're clear on with respect to the Jenkins Act, which is federal law, which requires these unlicensed distributors to inform states who purchased the cigarettes through the Internet, is a federal law. And like the judge indicated, there's nothing that's going to happen in New Jersey tax court that's going to allow you to somehow attack that law. Okay, affirming that I cannot argue my constitutional rights in this court. Okay, so here's the two professional lawyers telling the pro se plaintiff that they are excluded from making these arguments. You'd have to bring some kind of federal lawsuit. So he's operating under, you have to understand the concept of jurisdiction. You may not like it. So she's patronizingly informing me of what the law is, and she's inaccurate. She's a fucking Attorney General, and she doesn't know fucking what jurisdiction is. All right? And so let's understand in this document where I am trying to defend myself, Okay, I'm basically conceding I can't argue this case. I'm fucked. Okay, I mean, you fucked me out of my argument. And I state in here, I feel liberty to elaborate on the subject. If due process demonstrate little respect for clearly established due process, equal protection. Now it's under burden of proof. Here we go. All right. The catch-22 imbecility of effectively being obligated to successfully prosecute federal constitutional lawsuits before I come to this court with claims of state violation of constitutional law is an inverted perversion of the appropriate placement of the burden of proof. So I'm basically stating she's making a summary judgment argument, and you're denying me the right to you're basically saying I have to go to the federal court to establish what some sort of constitutional right to argue my rights in the state court? That wouldn't make any sense. She's basically saying I have to argue state taxes in federal court, which I can't do. The federal court's going to say, this isn't my jurisdiction. You have to go to state court. So it's clear, catch-22. Go to the federal court and try to argue state taxes that you believe are federally violative of constitutional rights. So they're basically saying you can't argue your constitutional rights in either court. You don't have any constitutional rights in the United States of America by these Harvard graduates' description of America. And this is justice in his opinion. This was a suitable justice. This was allowing me to make my argument and having my argument fairly defeated. That's what took place here. And that's what he's defending. And you fuckers are defending him. And that's who I'm talking to you here, you fucking cunt. And when I say you guys, or you people, or you... Yeah, I'm talking to the cunts who defend you. You're a despicable creature of no merit, worth, dignity, decency whatsoever. And anything that feeds you, anything, okay, that feeds you, is responsible for the shit that flies out of you onto all of us by even conceding your humanity. You fucking piece of shit. You're a liar, plain and simple. There's no way you can't understand how that's fucking preposterous. For a fucking attorney general, an assistant deputy attorney general, to preach to a pro se plaintiff wrongly on the subject of jurisdiction, the most fundamental aspect of somebody's capacity to file a lawsuit. Again, if I went to federal court with this case, the federal judge would have said you're in the wrong court. Fuck. Okay, so now he's back on making some kind of crap about the fact that, you know, the extent of the conversations or which ones took place when. And clearly what did take place was there was a off-the-record conversation which the Attorney General, Deputy Attorney General, and the judge were in an off-the-record conversation that wasn't declared to be off-the-record. The judge sent me notice of a conference. It didn't say off-the-record conference. It said a conference. Okay, so, you know, this is the bullshit of this. Okay, and that's in where the judge said he doesn't have jurisdiction, and that's where the judge said, you know, why aren't you claiming you didn't buy cigarettes? And then he also included the 5% penalty, and I twice told the judge, I think you're violating my constitutional rights in that off-the-record conversation. Then the Attorney General, after that conversation, we stayed on the phone, and then she told me, again, she reiterated that I can't argue federal constitutional rights in this court. Okay, both hugely inaccurate definitions of the actual law. So anyway, let's just do this little bit here.
Goldschmidt says, I apologize, Your Honor. The judge continues. Had I known that, we would not have had this telephone call.
Right, so now Goldsmith had sent me a letter informing me of tax amnesty, and it wasn't part of the record, okay? The judge wasn't sent a copy. So here's the Attorney General, okay, doing legal process in the case. Every piece of paper I file, I have to file a copy with everybody. I have to notify everybody that I did it, all right? It's part of the case. There's no right to do stuff and say it's not part of the case. No, it's all on the record. And so here, she hasn't even placed this on the record. She's conducting judicial process. She's sending me papers, and she hasn't informed the court that she sent these papers. What the hell is that crap? That's not legal procedure.
And then what she says was, I apologize, Your Honor. I thought, and then basically he says, Well, there's no reason. There is no reason for you to send it to me. It's really not a concern to me. Just wanted to make sure.
Yeah, it's not a concern to him, right? But there should be copies in the record. It should be part of the record of the case, so he should have got a copy anyway. He should be certainly have informed of it when he opens the case law, the case file.
Was aware of the program. That's the only purpose of the call. It is not intended as pressure.
Yeah, well, like I said, that's just you don't call somebody up and say there's a 5% penalty if you don't get out now, and call that not pressure. I mean, that's just complete bullshit. Sorry, no sale. This is not the umpire's job.
So if she had, sent the letter to him, he wouldn't sent the copy of the letter that she sent to you to him. He wouldn't have even called you.
Says you, okay? I don't think that's honest. I don't think it's the truth. Okay, because I don't think that's his intention. His intention was to imply and make it clear to me he doesn't want to deal with this case. It was clear.
That's judge's job. I'll call up the plaintiff and suggest they confess. Because, that maybe if I suggest they confess, and they sign a confession.
You already did confess.
Well, I'm sorry, I didn't. I didn't confess to the fact that I'm going to give up my right to protest. I certainly didn't do that. I didn't confess that the law was legal. That's what amnesty would have required, was me to say the law is appropriate. Now, I didn't say that. I certainly didn't confess to that fact, fatty.
Maybe if I suggest that that's what they should do, then maybe we can avoid the whole trial altogether. Maybe I can just nicely suggest that they give up and not bother trying to make an argument in my court.
No, again, that's not what he did. He was just he just didn't know that you were a witness.
Oh, I'm sorry. He sits there and says we're not going to discuss the merits of the case. But how come you didn't say you didn't buy cigarettes? So no, there's no sale, asshole. He's fucking obnoxious to my case, and he calls in and he just says you have a bunch of these arguments about constitutionality. Well, I can't do anything about your constitutional rights. So on 3 scores, he's calling me up, threatening me with a 5% penalty. He's obnoxiously interpreting my complaint as saying somehow I didn't buy cigarettes when I did, and I'm complaining about the proportion, the excessiveness of the tax, and it's all over my complaint, the excessiveness of the tax. So that's 2 counts, and then the 3rd count is, well, I just forgot it, but there it is. On 3 counts, he's violating my constitutional rights in an off-the-record conversation. Fuck you in this bullshit. You are just so fucking, obviously, distracted by your pettiness.
If you were aware of the tax amnesty program or not, firstly. And secondly, are you really bitching about fucking plea bargaining here? I thought you said you were all in favor of plea bargaining earlier, dear.
Well, again, it's not plea bargaining, it's threat bargaining. But just keep pretending it's not. Keep pretending that imposing a 5% penalty is plea bargaining. That's what they do when they plea bargain with a plaintiff. They go, we're going to give you extra years in jail if you don't confess. And that's called plea bargaining. No, I'm sorry, that's not how it works. They give them less time in jail if they confess. Jackass! God, you're so fucking dumb. All right, here we go again.
You have a fundamental constitutional right to make.
You did make those arguments, and he addressed them, and...
I'm sorry, right. It says right in my papers. I just point out I'm supposed to go to to prosecute federal constitutional lawsuits to claim a state violation of constitutional law. It's right in my papers. It's right in the argument. It's nowhere in their summary judgment motion. Once again, see narrow jurisdiction to state law, and I was denied the opportunity to argue my constitutional rights. I couldn't say, under the 14th Amendment as interpreted by the Supreme Court, I have these rights. I wasn't allowed to make those arguments, jackass. So don't keep saying I was, because I wasn't. And I clearly stated in my papers, and I quote the Attorney General stating that I'm not allowed to do it. You liar.
And I read out him addressing all of your arguments. You lose.
Okay, well that's the extent, that's the depth, right? He provided the explanation for how there is no discrimination. He explained how the law has been satisfied, okay, by some sort of analysis that shows how the vice of alcoholism is not similarly situated to the vice of cigarette smoking. He did that. The Attorney General did that. It's somewhere in the paper somewhere is this explanation of how alcohol is not as dangerous a vice as cigarette smoking, which is my complaint, that's the disparity. Show it to me, shithead. No, you're not going to show it to me because it's not in the papers. It's not in the fucking facts of the trial. It's not there.
Maybe that's why it's off the fucking record.
Yeah, okay, so again, that's how you respond to the fact that this judicial process violated the fundamental judicial process. So essentially, that's how you deal with a cheat. A huge cheat has taken place, and you're just going to say, so what? Well, that's what you should get. You should get justice just as poor as that. I would wish someday somebody looks at you and says, yeah, it's time to fuck this guy up.
13 minutes left in his video.
If it has been recorded. I believe I made a statement that I did not have jurisdiction over federal constitutional questions. Assuming I made that statement, I misspoke. Assuming I made that statement.
So, yeah, I mean, really, I'm just, again, assuming I made that, he's already conceded he made the statement. He's admitted he's made the statement. Assuming. Now it's assuming. Hilarious.
Right? This is the same asshole who's asking me, why don't you argue in your papers that you didn't buy cigarettes? Right? Assuming. He's heard the fucking recording. He's heard himself quoted. He's conceded. He said the fucking word. And now he's saying assuming. Assuming I made that statement. It was the fucking statement witnessed. That one was witnessed by the other fucking lawyer. I mean, she concurred in that fucking lunacy.
Yeah.
Yeah, but right after.
So now are you going to point out how? Okay, I guess Gary, you do remember that she was part of that conversation, and you just misspoke before about something irrelevant, and that's right. I irrelevantly misspoke. I didn't misspoke in an important constitutional right court case. No, I misspoke in a conversation about such a case.
After that conversation, remember, the three of us were on the phone, right, off the record, and then I talked to her right after that, and I said, what the fuck is this bullshit? You work for the Attorney General. The fucking judge just told me I can't argue constitutional issues. And then she told me I couldn't argue the damn issues. I apologize to Mr. Mosher and Ms. Goldschmidt. I do have jurisdiction over those questions, and I will address them over the course of my opinion today. Right. Okay, so Einstein, you understand what just took place here? We had a trial for a fucking year. And for that fucking year, I couldn't argue the constitutional issues, you stupid cunt.
Well, you did in your complaint.
There you go. Okay, I did in my complaint. My complaint was 10 bullet points. A complaint is just supposed to be an outline of what you're filing against. It's basically just saying, my neighbor broke statute 796 by coming over to my house and stabbing me in the neck. That's what a complaint is, okay? You're citing a law that's been broken, and you're going to argue that case, okay? But you don't make the argument in the complaint. So this is just bullshit that my complaint stands as my constitutional argument. That where in my complaint, well, I might even have a quote. I know I don't. Again, I should have the right to quote Marshall. I should have a right to quote Rehnquist. I should have a right to quote the Supreme Court of the United States in saying things like, explaining how deep a disparity in treatment can be.
Stupid ass fucking white.
Yeah, Gary, and his final decision was right, and there's nothing you could have said that would have. I mean, what slam dunk constitutional argument do you have that really defeats what he said?
Right in his own fucking... oh, man, you are so fucking stupid. In his decision, he cited Supreme Court decisions that I wasn't allowed to cite. And in those decisions, it says, similarly situated must be treated similarly. It says iron rule. It said exact precision. These are the very concepts and words that I could argue and say, I'm not arguing that there is no exact treatment. I'm arguing that there's a preposterously differential treatment. And then he would have to respond to that. But I wasn't allowed to make that argument, you fucking asshole. Gee, I mean, this is just outrageous. You just heard him. He just sit there, closed the case, and then said, oh, by the way, I did have jurisdiction. Ha 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 ha. That's what he just did, jackass. You can't do that. That's preposterous judicial process. It never happened in the history of the United States as the Supreme Court or any high court ever upheld a case where a judge did something this fucking stupid. You're just being a cunt, a fucking weasel, a petty fucking weasel. If this was any other person who was treated like this in a goddamn